owner has to pay compensation. In UNESCO Convention 1970, we have 182 members. In the Ira Convention, only 32. And it's mainly countries that exporting inverted commas that have got a lot of antiquities, or these are not countries. Germany has not signed it, Great Britain has not signed it, the United States has not signed it. So there's a huge difference. I mean, we have the countries of origin have signed it, most of them, and the countries of importing countries not. Why? The main reasons why they don't do it is the compensation, the fact that the Unilateral Convention is going too deep into the national law. They would have to change the whole way of thinking with a good faith purchaser and change. I mean, the changes they would have, or the application it has to the national laws, the application it has to the national laws makes everything very complicated. And of course, it's too risky for these countries. So this is the weak point of the main weak point of the Unilateral Convention. Please always try to see these two conventions together. The 1970 Convention and the Unilateral Convention, they should be seen as ideally as one. Let's go to the second level, EU legislation. I won't tell you too much about it. What I want you to know in this field is that it applies when you have a case where both countries are members of the European Union. And there are two legal instruments, the regulation on export and the directive on return. Now, why is it not so, let's say, not so important? Because the European Union is not responsible for cultural heritage. The cultural heritage is still a national issue. National law applies. So what the European Union has done has said, look, in the export regulation, it's a purely administrative regulation saying that if a cultural object is going to leave the borders of European Union, then we want to have a specific administrative way how that should happen, an export license and so on. So this applies to cultural objects that will leave from the European Union to somewhere else. The directive about the return applies when the cultural object is within the borders of the European Union, in two countries, Greece, Germany, for instance. The directive is, European Union officials are strong in thinking of revising it and changing some things, because in practical terms we have very little litigation based on the return on the directive. So EU legislation, remember please only, both sides have to be members of the European Union, and there is a directive for the return which you have to check if you are dealing with a case. Section D. The main, speaking with people, the main misunderstanding I see and I encounter is that they see a cultural object and they say it has to be returned. They never make the distinction which you have to do if it's a so-called old case or a recent case. Recent cases are cut-off date 1970, roughly speaking, I'm saying it roughly speaking, pieces that have left their country of origin after 1970. If we have got pieces that have left the country of origin many years ago, usually colonial times, most of them are in colonial times, where either the state was not existent, or even the law of the state was not existent, then everything I told you is almost not applicable. And I explain you why. So when you read in the newspapers that one country or whatever, or someone, an institution asks for the return of cultural object, first question will be, when was it removed? Is it a recent case or an old case? First one. And if it's a recent case, then you apply the 4 questions I told you, and then you go for the 3 levels: international law, European Union law, or national law. typical old case is, of course, the Gustav Nefertiti in Berlin. That's a typical one. Others, very famous one is Rosetta Stone, British Museum, Dendera ceiling in Louvre, Benin bronzes, which are also in Britain. What else? Many. And of course, the Parthenon marbles. What I try to do now is a bit tricky. And we have lawyers amongst us, and I ask for understanding because I have to be very, very vague and not 100% clear, but I'm doing that because I want you mainly to understand how the whole system works. That's my main interest tonight. So what we did in section A, B, and C, I want us to, in a mental exercise, to apply it as much as possible at the Parthenon marbles case. It's not 100% clear legally, but it will help a lot. Most of you will know that it's very crucial if there is a legal grounds for the return. Most probably there is not, and we are going to see now why. What did we say? We are working on the 3 levels. First level, public international law. First question. Is there maybe a bilateral agreement between England and Great Britain and Greece dealing with the return of cultural objects? No, definitely not. Okay, so we look for another instrument of public international law. UNESCO conventions. First UNESCO convention, 1970. First question. Always ask these questions. First questions. Are the 2 states part of the convention? 1970 convention, UNESCO, yes. Great Britain is, and Greece is. Good. Second question you have to ask, when was the object removed? Because all these conventions, they don't have a retroactive application. Before 1970, it's not exactly 1970, but keep 1970, whatever was removed before then, the UNESCO convention does not apply. And the third question you have to ask, we didn't go into that, but it's very important, is of this cultural object, is a cultural object according to each convention you are, or each law you are examining? I don't think it will be any problem with Parthenon marbles. So, 1970 convention, both states are members. It was removed before 70s, we are out of that, but even if we were not out of that, as I said, because it's not self-executing, you cannot go to court and say, give it back because both signed 1970 convention. So we are out of it. Next step. 1995 UNIDROIT convention. First question. Are the 2 states parties of the convention? Greece is. Great Britain is not. Out. What else can we do on this level? Another idea that lawyers came up to, it's a very clever idea, but I'm afraid it's too vague, is international custom law. What does it mean? It means that if, very easy speaking, if the same thing has happened many, many times, and we have a lot of decisions in that field and in that direction, then we can use this as a basis. Unfortunately, we cannot say that for the return of cultural objects. Far too few cases. It's a good try, a bit vague. I think we are out of that too, I'm afraid. You disagree? Good. You tell us afterwards, please. It's maybe the only thing we can base something on. But again, if we are to address an international court, then both sides would have to agree to that. You cannot go to international court and say, look, Great Britain has got my marbles, I want it back. Both have to agree on that. And most probably Great Britain would not. Most probably. So we go to the second level, European Union legislation. I don't think we have to go into that too much because the marbles were removed far before European Union existed, let alone that it's applicable from cultural objects that have been removed after 93. So we are totally out of that national legislation. And now I'm going into a very slippery way. And here is where I have to ask for forgiveness from my lawyers friends, because practically we cannot do what I'm going to do now, but I'm going to do it on purpose so that you can use the way of the system. Ownership. Greece would have to prove that it owns the marbles. Not very difficult. Nevertheless, Lord Elgin took them away based on a decree which we do not have. We don't know exactly what's written in it. We only have a translation, an Italian translation of it. I'm quite sure that this decree did not give him the right to go and take the pieces. But we don't know it 100%. Another thing that Britain could come up to, I mean, it's all theoretically, because on which law are you going to base this act for ownership? I'm doing it, it's just a game. Play with me the game to understand it. What Britain could say then is, okay, if Lord Elgin is not the owner of the marbles, then when did it happen? It happened back in during Ottoman time. Who is the successor of Ottoman Empire? Turkey. Most say Turkey. So Turkey could claim it. That's what Britain could say. Now, please don't go out and say that there's a lawyer stating that Turkey should. First, I will not survive it exactly. I'm not saying that. I'm not saying that. I only want you to understand the problems that can lie between ownership. Of course, it's a monument. We have the Greek laws. Of course, it's Greek. But you see, I want you to think legally, to see how different a lawyer has to think and with what he has to encounter. No, let's go to good faith. Again, we cannot really apply the good faith, but let's play the game. We could have a problem as we don't know what is written in the decree. It could have been, no one believes it, it could have been that Lord Elgin was in good faith. So he could have become an owner. Again, there's no legal grounds for it, so forget it, but play with me. Private international law. Which means which court to apply and which law to apply. Which court would be maybe relatively clear, since the marbles are in Britain, we would have to address British courts. Again, there we could play legally, but let's assume that we're taking that. A big, big question, this is the main question which eliminates what I told you before, which was just a game. Which law to apply? Greece entered the stage as a state 1832, and the Greek civil code a bit later. So we would have to apply Ottoman law, because when that happens, Ottoman law does not exist, and you can't go to any court saying, please apply Ottoman law. So this is our main problem. This is it. And if you go to number 4, time of limitation, I don't think that there's any legal system in the world that would accept more than 200 years after something happened to go and ask for it. Again, it's a game, because if you don't have number 3, if you don't have a legal ground, all the rest is just a game. You hear me? Oh, okay. So if you don't have number 3, all the rest is a game. So in my eyes, it's a bit difficult to find legal grounds for that. If my colleague Ms. Bathanasiou has another opinion, I would love to hear that. She represents our country on this issue. She's a very special person. So I would love to hear that. So in my opinion, it comes down to a sort of ethical question, if they should be returned or not. And there we have two main ways of thinking, which nowadays we use this "who owns antiquities" as a title for this whole dispute. Who owns antiquities is the title of a book written by James Kuhner, who is now the CEO of Getty Museum. He wrote a book claiming practically internationalists claiming that the encyclopedic museums should exist, and so I will tell you straight away what he was claiming. And his book had the title "Who Owns Antiquities?" So there was so much discussion about that for 2 years. Whoever deals with that issue got emails and book reviews and whatever. But nowadays, you use this title to address this dispute. What do the cultural internationalists say? I chose only 3 arguments. The one is material culture is the property of all humanity. So it doesn't matter what it really is. It should be there where most people see it and where it's safe. The second argument they use is that there is no linear cultural relationship between the cultures of modern nations. The country of origin is not the culture of origin. He uses examples like now China is in charge of Tibetan cultural heritage, or a Torah that was found in Baghdad. Who would mainly take care of it? Would it be Israel, as they are of Hebrew, Jewish religion, or is it Iraq, where the object is, but there are very few Jews left? And so arguments like that they use. And the third argument they use very often is that, look, ancient antiquities are used to foster nationalistic identities, and by supporting them we are supporting political directions that we don't really want, thinking of cases like Iraq and whatever. What do the cultural nationalists, on the other hand, say? They say, look, behind all what we heard before, it sounds very logical, but there's nothing else behind it than just fostering trade. They're interested in trading, they don't want to lose their rights, and that's why they're saying all that. Another argument is that cultural heritage is very important for each nation, and has special significance and for the identity of the nation, and therefore the nation should take care of it, and it should be in the countries of origin. And of course, the original cultural context should be kept. So this is a more ethical discussion. It's not a legal discussion. But I wanted to give you these 2 things, so I'll give you also the floor for discussion, whatever you think is closer. But I think you had enough for today. Too much law. But it's really a very interesting issue. I just showed you, it was very superficial, everything, but it goes much deeper, much more complicated. But what I want you to take with you is the main idea, the main structure. Always remember, first of all, old case, new case. If it's a new case, the 3 levels. See if international public law is applicable, European Union law is applicable, or national legislation. And then see the 4 main key issues. Is he the owner, good faith purchaser? Which law is applicable, which courts to address, and do we have a case of such a documentation? Thank you.